Look, guys, Windows sucks, okay? We know. We know it is super privacy invasive and it's not as secure as some of the other options out there, most of the other options out there, all of those things. We're well aware. But the fact is there's a lot of people out there that have to use Windows for a lot of perfectly valid reasons. For example, I'm an audio guy, and for many, many years, I made my living doing audio, and I needed access, I still need access to things like Pro Tools and a lot of the plugins that don't work on Linux. And sure, I can move over to a MacBook, but a Windows machine that does audio well costs half as much as a MacBook that handles audio just as well. Sometimes it costs even less than that. So not everyone can afford a Mac. Like I made a living as an audio guy, but I wasn't like rolling in dough. I didn't really have the money to drop on a MacBook. Windows worked great for me. And then, there's some people that like it's a work device that they're allowed to use for personal stuff, but they're not allowed to reinstall like Linux on it. And maybe that's the only device they have and they have to use that device for some stuff. Like there's a lot of perfectly valid reasons, whether it's temporary or long-term, that people have to use Windows. And then, there's some people that like it's a work device that they're allowed to use for personal stuff, but they're not allowed to reinstall like Linux on it. And maybe that's the only device they have and they have to use that device for some stuff.
Are you sure about that?
Our last political story comes from Australia, where an Australian privacy watchdog refuses to investigate employer that allegedly accessed workers' personal emails. The Australian Information Commissioner refused to investigate an employer that allegedly accessed an employee's personal emails on the grounds that the information was accessed on the employee's work laptop. So this employee was suspended from his job at a mining industry company called Mercus in June of 2019 and was ordered to surrender his work laptop. I'm not even going to try to pronounce this person's name. Had used his laptop for personal activity, including saving his passwords for online banking, emailing from his personal account, and accessing his online cloud storage. In a complaint to the Information Commissioner made in 2019, he alleged that his iCloud and personal email accounts had been accessed by his employer. He said that he had received a letter from his employer after he was suspended, accusing him of working on personal projects and contacting rivals during working hours. He was suspended on that basis, but he claimed that his employer could have only known that by reading the contents of his personal emails and accessing information from his iCloud account. The employer told the Information Commissioner that the information investigated by the company had been stored on a company laptop, which was in line with company policy. The employee claimed that the company did not have a policy on storing personal information on company computers, or if it did, it wasn't used in his 5 years of working in the company's IT department. The company denied it had used personal information saved on the laptops to access his online accounts and provided IT policies dating back to 2013. A delegate for the commissioner in September 2021 informed the employee that the employer had not interfered with his right to privacy due to the employee record exemption of the Privacy Act. He also said the employee handbook stated that all data created, stored, or transmitted on systems amounted to a work product. And quoting what the delegate said, "I consider that you were aware the work computer was not your private property and that any data saved to the computer may have formed part of your employee records as it was subject to routine monitoring and review. The employer does not require your consent to access or use the equipment that it issued to you to perform your employment duties. As the computer was a tool that the respondent provided to you to carry out your employment duties, it remains the property of the employer." David Vale, the privacy and surveillance stream lead at the University of New South Wales and Allen's Hub for Technology, Law and Innovation, that's a mouthful, said that the judgment is unhelpful for settling the law on this point, a consequence of the fact that a victim can't directly litigate their legal claim, and that, as the court confirms, at the present, Australians still thus don't have a right to privacy, only a right to complain to a regulator who can, as this judgment confirms, take advantage of a wide range of justifications to do nothing if they feel like it with minimal court oversight. So basically he's saying, like, I was hoping this would go to court so we would have legal precedent on whether or not people have a right to privacy in this situation, and it's a bummer that it didn't go to court.
Now, what was it you said earlier about using work devices for personal use?
And then, there's some people that like it's a work device that they're allowed to use for personal stuff, but they're not allowed to reinstall like Linux on it. And maybe that's the only device they have and they have to use that device for some stuff.
In other words, your example was not only proven wrong, but was also shown to be dangerous advice to give to viewers. Funny how you were awfully quiet about it during the news story and didn't think to acknowledge you were wrong.